to specific provisions of the law to justify the application of the order sought. Allow me to concentrate on just these two documents.
Just a moment, just a moment.
Most obliged.
I have tried to limit time so that we do not sit at night. Hours of darkness begin at 6:30. It's now 6:40.
You know, we sat here up to 4 in the morning.
Let me finish. So we are going to stop at this point. Whatever submissions that are remaining, because we will not finish today. Because we are at Mr. Welle, this side.
We donate our time to the other Mr. Omar.
I did
And then let's get
I'm the president.
And then now Mr. Riungu and his team have to respond.
We can take 7 minutes in
Sorry,
response.
let me finish.
Yes, Your Honor,
So it is
from the 6th and 7th, I donate the time to my seniors.
So it is getting dark and we have a crowd inside the building. I know you don't work here, but there's a danger in keeping this large number of people within the court premises at night. I have tried to control Mr. Welle, but he's going on and on, so I
Your
cannot
Honor,
stop him further.
I would not want to be the one to hold this gentleman here for any longer. I am happy to take your directions on how you wish to limit my time.
What I would prefer is that if you are likely to take
I'll take the time you donate, Your Honor.
another period of more than 5 minutes, then it is better we stop at this point and we continue tomorrow.
No, I'll conclude. I'll conclude. Within those 5 minutes, I'll
You
conclude.
are sure you have covered all the areas you wanted to cover?
Your Honor, in the interest of the accused who have been held for so long, I will do less than 5. I'll limit myself. If it gets to 5, just cut it down. Yes, I will take less than. Yes. Let me just conclude the point that I was trying to make here. So, Your Honor, the compelling reasons that the DPP provides can only be gleaned from these two documents before you. Very briefly, Your Honor, please refer to the charge sheet as against the application before you. Review that charge sheet. The offense that the accused persons have been charged with against the offenses for which the prosecution now seeks to hold them are diametrically different. You have been told, Your Honor, that the accused are likely to be a danger to witnesses. Your Honor, look at the charge sheet. All witnesses are police officers. They are all police officers. I will not belabor the point. You have been told that the accused persons are a danger to national security. That submission has come to you from the bar. No evidence has been adduced to back it up. But nonetheless, Your Honor, there are certain presumptions that this court cannot lose sight of. And some of those presumptions are in this Constitution. The security apparatus of this country follows a very clear structure created under the Constitution. It is for the DPP to demonstrate why he believes that these accused persons have the machinery or capacity to undermine why it has not been demonstrated to you why these accused persons, or how these accused persons will undermine the entire fabric or structure of that apparatus as created and contemplated under the Constitution. In the interest of time, Your Honor, I'm pleading with you as demonstrated by my learned friend Mr. Okach. These are Kenyans. Unless and until they are convicted of the offenses for which they have been charged, their constitutional rights under the Bill of Rights, and particularly the presumption of innocence, persists and are not suspended by the mere fact that they are now seated on that dock. Grant them reasonable bail terms. As your learned brother, Justice Mugambi, intimated, they cannot be incarcerated because certain individuals have broken the law out there. For those reasons, Your Honor, we pray that you disallow the application and allow these accused persons to reasonable bail and terms.
On behalf of the other accused persons, I'll take strictly 5 minutes. I'll not mention any law. My good friends have mentioned the Constitution. I'll only bring the context that brings them here.
Okay. Just one moment. Just to mention it. Yes, Mr. Man.
Thank you. You're a very fast one. I'll base all my arguments on Article 27 of the Constitution. Non-discrimination. With the following 5 points. All the 7 accused people come from one political party called ODM. Secondly, Your Honor, they are members of Azimio. Third, they are all politicians. Fourth, they all come from the Luo ethnic community. Fifth, Your Honor, this is a proper ethnic political profiling.
Your Honor, with all due respect.
But they'll have time.
You have your time to respond. You have your time. Right, sit down.
Relax. I said 5 minutes, I've only 2 minutes
Don't
to go.
interrupt.
Your Honor, this affidavit has no date. That's the second line, when it was sworn. This affidavit is as old as 2017. It is the same affidavit that was used to arrest the ruling class now. From 2017 to 2022, it's the same affidavit. And all those that were charged based on this affidavit, their charges were withdrawn. The court should take judicial notice that the same police officers who swore this affidavit came to court and said they were forced.
So your objection, that line with respect.
That is judicial notice OET.
The officer that default to this affidavit is before court. I haven't seen him ask Mr. Omari to talk about on his behalf. We just pray that that last line be ignored.
You know, Your Honor, it is me who represents them when the DPP wants to charge them. I'll give you specifically to the officer who swore the affidavit for the deputy president. When that affidavit was dissolved, the officer came to court and said he signed the affidavit under duress. It's specific and it's on the court record. So,
our clarity is that for purposes of today, the IO that swore this affidavit is before court. He has not spoken to Mr. Omari. Mr. Omari might have done very well in other cases, but this affidavit has not been said to have been sworn under duress. That's the only clarification I'm making. For today,
Your Honor, I'm giving Mr. Witty the perspective that come 2027,
The same will be used.
the same will be dissolved, that it was signed under duress. For now, it will not be dissolved. So that the court, as it is, it looks at the whole political context. Lastly, Your Honor, on this affidavit, I want to bring to the attention of this court that it is only the judiciary that is going to protect Kenyans. A great responsibility is on this independent arm. The political duels outside should not be criminalized. And we urge this court to see far and remove the political contests from criminal issues. This is a political matter before you. Deal with it the way it is. So, Your Honor, out of that 5 minutes I've finished, I allow the President of the Law Society of Kenya, before he removes me from the role of practicing, to talk. Okay.
Let me see it. I wanted you to see this affidavit is the same that Chunga used. Chunga was not there. I wanted to bring the contest.
Your Honor, with your very kind permission, I recognize the predicament. Yes, sir.
Eric, I know it's not normal to.
His Excellency, the President.
See what is happening, Your Honor, in this court.
Just give me a few minutes, I sign this.
Okay.
I have so much to do.
That's in order.
This is the political contest. The organization of the state. And the profiling. All these are rules. Na unaona watu ni wabaya sana. Wanafanya kitu ndio Ionekane vipita hivi. Angalia. Kwanza vile wanataka kutoka. Wanafanya vile tunakuwa sori na mgeni wetu. Sisi tuonekane. Yes.
Even the pages, they make changes of the name of the people.
Yes. They changed the name. This affidavit will be used in another case. It's wrong. It's in the article of profiling. That's the profiling I was telling you. The magistrate. But I can't she's illiterate. Legally illiterate. Yes, I wanted you to say that.
I'll address it properly when I'm after. Because that's my fault. That's my fault.
Wengine watu wamekaliwa nao mawakili sana. Kuna wakili hapa hajaongea kitu ya maana. And they brought their best bet. Sinaona kani retweet 5 o'clock najua kama naipiwa na watu wengi na retweet. Yes. They're not. You can profile our community.
Yes.
Very, very brief remarks on behalf of all the interested persons.
Are you comfortable submitting at night?
5 minutes at most. My colleagues have already submitted on the law and what is before you. Envy in the position you find yourself. And neither do I envy the position that the prosecution finds itself. Your Honor, by the prosecution is to employ unconstitutional means the whole purpose of Article 49 and Article 50 of the Constitution is to uphold the dignity of the human person and also to uphold the dignity of this court. So you're right, it's my humble submission that should you in the manner in which it has been presented, manner in which all the accused persons were arrested and treated, then, Your Honor, you will undermine the dignity of this court. Your Honor, this court to not only uphold the authority of the Constitution, but to also give confidence to the Kenyan people that in the Republic of Kenya, in as much as I said that I may not envy the position you find yourself in, I think that what is before you is a very simple duty. To the police, to the prosecution, to the country at large.
Do you mind if I interrupt you again? Just another 2 minutes and be done.
Thank you.
Yes.
Yes, Your Honor, I was saying that through their pronouncements. And so therefore, Your Honor, I submit that your duty to the prosecution, to the police, at large, that these courts intend to remain and that any infractions on the Constitution but I say this because we are witnessing a dangerous trend of suspension these courts speak, there'll be no one left to speak for all of us. To release 5,000, not more than 5,000. So that they can go. Because these proceedings constitutional impropriety. That we have to waste precious judicial time I therefore join hands with all my colleagues and beseech this court and to release and to affirm to these accused persons that they will always be protected and affirmed by this court. Your Honor, I thank you for understand that these are extraordinary times, and so they do call for extraordinary measures. And Your Honor, I thank you. If it is possible, Your Honor, would be happy to have your decision now. If it is not possible, because we understand that would be more than happy to have your decision early tomorrow morning. Be important that they be remanded in a police station Your Honor, I'm also being informed that this is just for purposes of serving on time. I'm also being informed that the first accused is unwell, to their advocates to see their clients. And the members of their family not be curtailed. Your Honor, I thank you for
Mr. Yungu, I made you rush, and then I tap run for the defense. I'm not sure I should limit you again. I'll let you proceed. But just an indication, how long will you take?
You know, because of the abundance of kindness that you had, our learned colleague, Mr. Witty, is going to respond. And he had indicated earlier 7 minutes. I think we got additional 3 minutes of the submissions, including that have been made by a president. So, really mind is getting 10 minutes.
Thank you, Your Honor. I will undertake to do under 10 so that I don't keep my seniors here, including my president, who today seems to have forgotten. Having said so, Your Honor, we have listened carefully to submissions from our learned colleagues for the defense. And we understand where they come. I am reminded that I should go slower than my usual speech. When I was indicating to court that has been on alleged, and the word alleged is chosen deliberately, alleged violation of fundamental rights and freedoms. My submissions will start from that point. And our invitation to this is that when you whether the respondents should be released on bail pending hearing and determination of the charges before you. At this point,
Just a moment.
and that rule applies also to independent issues before you. Is whether or not this honorable court can entertain here and or determine to which Your Honor presides is defined and prescribed by Section 8 of the Magistrates Court Act, on human rights. And that section says questions of alleged violations of Articles 25A and B.
Just a minute.
Your Honor, Articles 25A and B. And that means legal representation, the alleged violation of the right to food, the alleged violation of the right to discrimination, right against discrimination, which was raised by Malay 7, all those fall out of your jurisdiction. And you cannot hear. In fact, in normal expectation, it would have been that the submissions on those points. You cannot hear and you cannot make determination around them. This is not to say that the ODPP, whose jurisdiction forum for that determination, the forum for such a hearing is outside your mandate, and they cannot be the basis of your consideration. For the avoidance, the jurisdiction to hear and determine questions of alleged violation of rights and fundamental freedoms belongs to the High Court of Kenya. (165) related thereto is the jurisdiction to hear and determine any question as to whether any law is in violation of the Constitution. My learned colleague, Mr. Okach, tells you that Section 77(1) of the Penal Code was used an outdated law. We may agree, probably. However, it still forms part of the Penal 63 laws of Kenya, and more importantly, you have no jurisdiction to determine the constitutionality of Section 77(1). That aspect cannot form the basis of your determination on board. However, Your Honor, for complete Sorry. For completeness on the question of jurisdiction, if, and this is an if, even if the of a late violation of rights outside Article 25A and B, and therefore could find or make a finding that there indeed was a violation of the rights of any of the respondents. Even if you could find that there indeed was a violation, Your Honor, I stress again that the prosecution is not saying there was or there wasn't. The Court of Appeal in Kenya, in the case of Julius Kamau Mbogwa.
Just a moment.
Sorry.
You are very fast.
I'm sorry. I was born a quick speaker. I am struggling to go slow, but I'm trying.
Yes.
The Court of Julius Kamau Mbogwa versus Republic. Julius Kamau Mbogwa versus Republic. Criminal Appeal number 50 of 2008. Number 50 of 2008. This decision is equally reported on the Kenya Law Reports 2010. And as correctly noted by learned counsel Mr. Mr. Awele, that a violation of fundamental rights does not go into the root of a charge. We are again not saying there wasn't or there was. This court has no such jurisdiction. But even if that finding could be made, that violation, which can only be heard by the High Court, cannot go into the root of the charges before you, but is compensatable in damages.
Of objection. Nobody raised the question of jurisdiction and determination of constitutionality of sections. Council is dealing on an abstract matter. My two councils say here they shall follow that elsewhere. So we have not said this court has no jurisdiction. Should declare the charge sheet defective or unconstitutional. That is the only matters that were not raised by any of the defense counsels.
Yeah, just to help the court contextualize, when Mr. Malene rose, the first thing he told you is that he was going to give you a context and not the law. However, as he started, the first thing he told you is there is a fundamental issue of Article 27 been in record. So what I'm basically saying
if I bring him clear, Article 49 that defines provisions for compelling reasons is a constitutional.
Let me deal with the question. No,
that the courts here, magistrates, look at Article 49.
Yes.
They apply it,
yes,
but they cannot interpret it. So what we are trying to say is that Your Honor, we are not asking for constitutional interpretations from you, or a finding that is based, or a constitutional finding. All we are saying, apply those ones as the law allows.
Thank you, Your Honor. That admission works for me. I have actually finished my submissions on that. I just remind you that all the articles of the Constitution that were raised cannot be heard or determined by this court, and we will wait to address I am done with that question. And Your Honor, we plead with the court to take down that admission by counsel, that they admit you are not the right. Secondly, I now come to the question of the role of the Office of the Director of Public Prosecutions. We have been accused for coming with unclean hands before you. Learned Counsel Ms. Bashir factual maxim, not applicable to criminal law, that anybody who comes to equity must come with clean hands. Anyone who comes to equity must come with clean hands. Even if the maxim were applicable, the obligation to prove has failed to prove that our hands are that, in fact, according to her, we should have been the one to prove that we have clean hands. That's against the rules of it. However, Your Honor, this is very critical, considering the context of these prosecutions as established under Article 157 of the Constitution. Has a role that is circumscribed. That role is clearly delineated. I will tell the court one thing that role does not include. It does not include supervisory powers over. Put differently, the Office of the Director of Public Prosecutions is not an appendage, neither of the National Police Service, nor of any other agency in the Republic of Kenya. Why do we say this? Sorry, Your Honor. Questions have been raised as to right to liberty, the arrest of the respondents. But at what point do you trigger the powers of the Office of the Director of Public Prosecutions? The powers of the DPP in exercising the mandate under Article 157(6) of the Constitution are only triggered when an investigative agency has forwarded an inquiry or investigative file. The investigative file, the subject of this matter, was forwarded to the office today, and in record time, around 4 hours, the decision to charge, which in ordinary cases is made within about 14 days. In 4 hours, we had made the decision to charge, and we are before you.
You understand, to help of counsel, I know the office of the DPP is vacant and he might be shortlisted to contest for that position. Let us look at Article 157(4). if he will be confirmed as the next ODPP, he has the powers to direct the police. If he's admitting here that they do not have that power, then we have a big problem.
Your counsel is deliberately misquoting me.
Or unless it's not a
think to his advantage. The powers under Article 157(4) of the Constitution is given, in fact, it's the only power, the rest are mandates, to carry out investigations into alleged criminal activities. That cannot amount to supervision. In fact, you read Article 245(4) of the Constitution, which, sorry, Your Honor, the law in me is...
Be careful, you might be seated there.
So Your Honor, the supervision of the National Police Service is elsewhere, not with the ODPP. And like I have a note, a conveyor belt of charges. For us to come before you today, the Office of the Director of Public Prosecutions Act number 2 of 2010, on which the only test required of the Director of Public Prosecutions, or those of us exercising delegated authority, is whether or is evidence with a realistic prospect of a conviction. We may have been wrong in making our decision all right, but that is the... And that's why we have presented charges before you. We shall be expected to bring evidence.
Your Honor, if I... With your kind permission, Your Honor, and just to save the court's time, and my colleague comes from my region, so he wants to speak a lot, but there is no question about their power or the decision. Absolutely theirs. The question that is before you is that affidavit that denies them bond. They've already taken plea. We are okay with that. We'll deal with that. But reasons, and he's avoiding that because there is no compelling reason.
Your Honor, I have that as my next issue. The court was here when a lot of arguments were made on has violated the Constitution. We have a right to respond to that. That's actually why we're representing the ODPP here. That accusations were made against us. So just like we were very patient with counsel, let them be very patient with us. It is very important to us, just like it is important to their client's case. So I plead with this court to allow me to respond to all the issues that they raised, and I'm almost done. Next point is on the question of Article 49, on whether or not there exist compelling reasons. And Your Honor, we started with the question of jurisdiction. To guide this court with humility, that is the only question that arises for your determination, not the 98% of the submissions from the defense. Your Honor, first of all is the technical question about whether or not the affidavit is dated. It is not. However, A look at page 2 of the application makes reference to the deponent of the affidavit. Page 2 of the application. It identifies the deponent of the affidavit, and the affidavit speaks to the grounds in support of the application on the same page, page 2. Those grounds are 1 to 4 on the face of the second page. And finally, on that page 2, the application is dated. We therefore invite you to invoke Article 159 because the affidavit is stamped duly and it is signed. Invoke Article 159(2) and find it proper. For the avoidance of doubt, no application was made to you to strike it out. To the substance, when you retire, Your Honor, you are going to ask just one question. And that's probably what should have come from the defense, and we should have responded to rejoinder, whether or not the prosecution has established any compelling reasons to deny any of the respondents' faith. I reiterate the submissions of my learned senior on the contents of the application and the affidavit. Only to further refer this Honorable Court to clause 4.9 of the Judiciary Bail and Bond Policy Guidelines. Clause 4.9. And more specifically, 4.9c on character and antecedents, 4.9e on possible interference with investigations, and 4.9g on possible interference with witnesses. Those grounds are again on the face of page 2. Just before we go to page 2, the prayers on the application, and then on page 2 we say the grounds number 2, number 3, and number 4. Likelihood of interference with witnesses at ground number 3. Likelihood of interference with ongoing investigations, and finally the possibility of committing similar offenses, which goes to antecedents. Where do we get the facts? My learned senior, Mr. Awele, asks the question, whose reasonable belief? The belief is of one Corporal Geoffrey Mwangi. He identifies that belief in the affidavit, as should be done. What is the source of the belief? He identifies.
Your Honor, this is usually not my ordinary playground, as Mr. Whitty knows it. But I believe the rules still apply. He is supposed to be limited to questions of law in his rejoinder. And I think it is unfair for the accused people for him to start raising or making unusual, factual allusions that we will not have an opportunity to explain.
You're in conclusion.
On that basis, because I was silent. JV, Learned Counsel for the DPP, when I on the date of their offer, they never disclose, and this is their charge sheet, unless they are denying it.
That's okay. Your Honor, we'll address that last. I was concluding on the issue of whether or not there's compelling reasons. We invite you to look at that. Sorry, Your Honor. Sorry.
The issue that Mr. Owino is raising.
Yes. It is the reason that I have said I'm concluding on that issue so that I don't go on the issues of facts. I think that was guidance.
Yes.
I am very well guided. And in conclusion, we invite you that when you retire and look at the matters of fact on the affidavit vis-a-vis the prayers in the application, you find that indeed there has been established compelling reasons to deny bail. There are two questions of law that are left, which I conclude with. Edwin Shisanya Amboso versus Republic is a decision of the Honorable Justice Mugambi that you've been referred to. We have agreed, and it makes sense, that there is a distinction between the orders granted in Edwin Sishanya, which rejected an invitation to declare assemblies unconstitutional or to issue conservatory orders to that effect. The charges before you, 701 of the Penal Code. We admit and agree with the defense that there exists order, the right to assembly.
Thank you.
We, however, are saying that what we have brought before you is charges for alleged criminal offenses. Finally, the question about the dates on the charge sheet. I would have one of them, section 89.5. There was no invitation from the defense or any allegation that there was on the charge sheet. And there's no order of this court rejecting charges, which would have happened under section 89.5. Number two, of the Criminal Procedure Code provides for an allowance in error of dates and names, among many other errors, and so that will affect the validity of the charges. Number three, suo motu or upon application by the prosecution to amend charges. That is still available. That power and right exists all the way until before the accused is placed on his defense. In conclusion, to send a message. I'm only concerned about the message you're sending to the prosecution. We plead with you that we are not we have not shown, or you've not been shown any fault on our part to send any message. Is to determine under Article 49(1)(h) whether or not there are compelling reasons or not. We welcome it.
Is JV threatening the court?
Issue have been reminded about place of detention. Should this court not be able to make a determination in the next few minutes, and I have been advised by the leading me today that we are not objecting to the accused persons being held at a police station. However, she's advised me that the police officers will.
Honorable, let me tell you. Off record. The day they'll arrest you, they'll take you to come. That is a honorable. When I was dealing with the SSU matter, I'm only talking to him as a friend. This is off completely record. I'm advising him.
We
off
can
record.
talk about this off record outside.
No, I'm only advising state officers.
Your Honor, again off record as he sees, he has applied to be my boss. Your Honor, we are done. I'm just the accused persons being taken to a police station. And when you become my boss, we will still do this.
Thank you. Thank you.
No, mine under me it will be very different.
Thank you, Your Honor, for your time.
Your Honor, very. I know it's completely out of order, but I couldn't fail but notice one thing which my learned good friend did mention, that ordinarily the decision to charge takes about 14 days, but they did it within a record 4 hours, which of course we commend, even though we have reason to worry about the speed at which they approved that charge. Secondly, my lord, some of the suspects who were in Wanguru were also driven here at extremely high speeds. So that means I'm just speaking to the urgency in resolving this matter and still renewing the plea that we made before you. Understanding, Your Honor, that really you've had a long day. But if we can get a decision from you before we depart from this court, greatly indebted to the court. But in the event that then at the earliest, Your Honor, I just thought that